someone who's been in PERS and has retired, and has been retired for a period of time prior to 2011, and received a COLA, and that COLA now, is it your position, becomes part of the retirement allowance, which cannot be reduced going forward?
Well, Your Honor, 2 points there. Just to make sure we're on the same page, the COLA is always separate and distinct from the retirement allowance.
And over periods of time, I realize that sometimes there's a formula for calculating it according to the CPI, and that over time there have been times when the legislature has determined what percent of the CPI will be the COLA. But if someone has retired and they've been retired long enough to qualify for a COLA, and they received that, is it your position that that person's retirement allowance is now the basic allowance pursuant to their system, with the addition of the COLA they received?
Your Honor, I think that presents, and I hope I'm answering your question, I think that presents an analytically distinct question. Here, what the state did was say that the person is going to continue to receive the retirement allowance and the COLA frozen at 2011 levels. So their benefit is not being reduced in any way. The person is still receiving 60% of the difference between the CPI in the year they retired and 2011. What the state has done here is say that going forward, post-2011, there will be no increase in that level of COLA based on changes in the CPI. The state here is not reducing anything that retirees have already received. That, I think, presents analytically distinct questions about property rights and things that are not an issue.
But I'm just, as I said, trying to actually put it in very concrete terms. If someone had retired and had a retirement allowance at retirement of, say, $1,000 a month, and over time, because of COLAs, in 2011 was receiving $1,100 a month, that it cannot be reduced.
That, Your Honor, is what the retiree is still receiving, and whether or not that can be reduced is not at issue in this case and entails an entirely different analysis. What the federal government has said in the Zucker line of cases is that once a COLA is received, as you just indicated...
It's essentially it attaches.
Right. Well, once it's received, and so the $1,100 level, what the federal government has said that once it's received, then there may be sort of property rights that kick in. But until it's received, the Congress is okay to freeze it going forward and not give any additional.
So the state is not is taking the position that as I said, that now $1,100 that was being received cannot be reduced.
Your Honor, we're still saying that the non-forfeitable right does not include COLAs, even COLAs that have been received. However, whether or not that could be reduced below 2011 levels, I mean, that's an issue that we would have to brief and discuss. But it's not what's happening here.
It's not what's happening here. Okay.
So you're not, just so I'm clear, you're not even willing to concede that the COLAs that have been attached to the salaries of retirees from 1997 to 2011 cannot be reduced? You're not willing to commit that? Are you suggesting that that the retirement amounts that retirees are receiving today cannot be reduced? You're not willing to commit to that?
Your Honor, what I'm saying is the COLAs, even after they are granted, do not somehow become part of the non-forfeitable right. And what I'm saying is that presents analytically distinct issues which the state has neither thought about nor briefed. What we have here is there is no reduction because retirees are still receiving the amount that they've always
Yeah,
received.